Personal injury law runs on two completely different business models. The plaintiff side runs on contingency, the defense side runs on billable hours. AI just broke both of them at the same time, and it broke them in opposite directions. Here is the part nobody at the top of either kind of firm wants to say out loud. One of those models punishes the firm for being slow. The other one pays the firm for being slow. Same technology lands on both. The outcome could not be more different. By the end of this video, you will understand how artificial intelligence is rewriting economics of personal injury law firms on both sides of the courtroom, why plaintiffs' firms are about to run leaner and move faster, why defense firms are about to make money in a completely different way, and why all of this is good news for the person who has been ignored in this conversation, the client. I'm a trial lawyer. I run a plaintiff-side personal injury firm in New York City, and I teach AI and litigation at Cardozo Law School. I'm watching this shift from inside the courtroom and inside the technology at the same time. And I'm telling you, the economics of this profession are being rewritten right now, quietly, while a lot of firms are still arguing about whether AI is a fad or not. A law firm is a business. Strip away the wood paneling and diplomas, and a firm runs on a simple equation. Revenue comes in, overhead goes out. Overhead is rent, salaries, staff, software, the cost of carrying the work from start to finish. The space between those numbers is whether the firm survives. But the two sides of personal injury answer that equation in completely different ways, and that is the whole story today. So let me take them one at a time, starting with my side of the courtroom, the plaintiff side. On the plaintiff side, AI does not make lawyers slightly faster. It attacks overhead at the root. A plaintiff's firm works on contingency. We do not bill the client by the hour. We front every cost ourselves, and we wait, sometimes for years, to get paid. That means every hour a lawyer or a paralegal spends on a file is an hour the firm has financed out of its own pocket with no guaranteed return. Overhead is not an annoyance for a plaintiff's firm. Overhead is the risk. Now, think about where those hours actually go. Medical record review. A serious case generates thousands of pages from multiple providers, and someone has to read all of it. Build a chronology, flag the gaps, connect treatment to the incident. Record requests, intake, summarizing depositions, assembling exhibits, drafting the routine, repetitive sections of discovery responses. The lengthy, grinding paperwork that eats weeks and produces almost no actual lawyering. None of that is the practice of law at its highest level. All of it is necessary, and for a contingency firm, every one of those hours is financed risk sitting on the books. AI does the first pass of that work in minutes instead of days. Let me be precise, because this is where lawyers get nervous. AI is not replacing the lawyer's judgment. It is not deciding what the case is worth. It is doing the reading, the sorting, the first draft, the assembly. The lawyer decides everything that matters. The lawyer just is not the one financing 40 hours of page turning anymore. When I say AI cuts overhead, lawyers immediately hear layoffs. That is the wrong instinct, and it is leaving the real advantage on the table. The opportunity is not fewer people. It is the same people freed from the grind and pointed at the work that actually wins cases. Think about what your team is doing while they are buried in discovery paperwork. They are not getting ahead of the 8-ball on case strategy. They are not drafting aggressive, well-researched motions. They are not pushing demand letters out the door faster. They are certainly not moving cases toward resolution while the file is still fresh. Every hour your staff spends drafting boilerplate discovery is an hour they are not spending on offense. That is the real shift for a plaintiff's firm. AI takes the defensive administrative grind off your team's desk, and your team redirects the same capacity into offensive litigation work. More motions, more demands, faster case movement. The firm does not get smaller, it gets sharper. You stop paying skilled people to do work that does not require their skills. Faster cases are not just a margin story. They change outcomes for clients. Here's something people outside this practice do not understand. Delay is a weapon, and the insurance carrier knows how to use it. An injured client with no income and mounting medical bills feels every month a case drags on. The carrier feels nothing. Time pressure is asymmetric, and the carrier uses that asymmetry to grind settlements down. The longer they wait, the more desperate the plaintiffs get, the cheaper the case becomes. When a firm builds its case file in a fraction of the time and gets demands and motions out faster, that asymmetry shrinks. The case reaches its value before the client is financially exhausted into accepting less. Speed is not a convenience. For an injured client, speed is leverage. Now let me cross the courtroom because the defense side of personal injury is about to have a much harder conversation. On the defense side, AI does not break overhead. It breaks the link between headcount and revenue. Defense side litigation runs on billable hours. A document review that takes hundreds of hours generates 100 hours of revenue. That has been the model for a century. And here is the uncomfortable truth at the center of it. The billable hour rewards slowness. The longer the work takes, the more the firm earns. For 100 years, that was an awkward secret the profession lived with, because the work genuinely did take the hours. Now run AI through it. That 100-hour review becomes a 10-hour review. Here's the trap. A defense firm billing by the hour just watched 90% of the revenue on that task evaporate. A firm on a flat fee just watched its margins on the same task multiply. Same technology, opposite outcomes, the only variable is the fee model. I want to be careful here because this next part is where defense lawyers either lean in or tune out. I am not telling you the defense bar is about to make less money. I'm telling you the defense bar is about to make money in a completely different way. Think about how a defense firm is actually built. The business model is leverage. You hire as many associates as you can, you bill their hours at a rate well above what you pay them, and the spread is the profit. The whole pyramid, partners at the top, layers of associate underneath, exists to generate billable hours at scale. More associates, more hours, more revenue. That is the engine. AI does not necessarily shrink the revenue. It breaks the engine. When the hours collapse, you can no longer build a firm by stacking bodies and billing their time. The firm that wins is not the one with the most associates. It is the one that prices its work well, delivers it efficiently, and keeps the margin. The money does not have to disappear. The leverage pyramid does. A leaner defense firm running AI and pricing flat fees intelligently can earn just as much as the old 100-associate shop, and possibly more, because that margin is no longer capped by how many hours a human body can physically bill in a year. That is the real disruption on the defense side, and it is not a doom story. It is a restructuring story. The firms that understand they are in the business of resolving cases, not the business of generating hours, will be fine. Better than fine. The firms that still think their headcount is their asset are the ones in trouble. And this is not a hypothetical I'm inventing. The shift is already underway, just not where most personal injury defense lawyers are looking. Transactional law is already off the billable hour for huge portions of its work. Routine corporate filings, contract review, trademark work, standardized M&A tasks. That work moved to flat fees years ago because it was predictable enough to price, and clients refused to keep paying open-ended hourly rates for it. Alternative fee arrangements are no longer the exception in those practice areas. They are the norm. What AI does is push that same logic into litigation. Once a task that used to justify 40 hours takes 4, it starts to look predictable. And predictable work gets priced as a flat fee because the client can finally see what it actually costs. I'll say this plainly as a forecast, not a fact, and I'll be fair about it. The billable hour is not dead today. Most firms are still built around it, and plenty of serious people argue it is still too early to call. They are right about that today. But we are clearly approaching the point where it stops being the default, and the direction is not in real doubt. AI did not create that pressure. The billable hour always had misaligned incentive at its core. What AI did was take away the last defense for it. The defense firm could always say this work genuinely takes the hours we bill. That sentence is no longer true, and everyone in the room knows it. The defense firms that move first will rebuild their economics on purpose and frame it as strength. The firms that move last will be restructured by their clients instead, and they will get worse terms for waiting. Usually, when an industry gets new technology, the savings stay with the firm. Here, the pressure runs towards the client on both sides of the courtroom. A plaintiff firm with lower overhead can take cases that were never economically viable before, which means injured people who used to be turned away get a lawyer, and they get a lawyer who can move faster. A defense firm pushed onto flat fees means the corporate client stops paying a premium for the inefficiency and finally knows what its legal spend will be. Faster, cheaper, and more predictable on both sides for the people actually receiving the legal service. That is rare. Pay attention when it happens. So here's the practical part. If you run a firm, or you are going to, how do you actually adopt this? Do not start by buying a chatbot and telling your associates to use it. That is what most firms are doing, and it is the weakest possible move. A general purpose chatbot in a browser tab gives you a slightly faster typist. It does not change your overhead because a human still has to prompt it, supervise it, copy the output, paste it into a real file, and check it. You automate the easy 10% and kept all the friction. The real shift is not AI that answers questions. It is AI that does the work. The distinction that matters is between AI you operate and AI that operates. A tool you drive task by task is still your overhead. An autonomous system that takes a whole workflow, intake to discovery responses to demand package, and executes it end to end while the lawyer supervises the results, that is what actually moves the economics. So here's what I would tell any personal injury lawyer adopting AI right now. Stop looking for a tool that makes you faster at your tasks. Look for an autonomous system that takes the tasks off your desk entirely. Identify the 3 workflows in your firm that consume the most hours and produce the least judgment. Medical record summaries, intake, routine discovery drafting. Those are your first targets. The goal is not assistance. The goal is execution. The plaintiffs' firms that understand that difference will spend the next decade running offense while their competitors are still buried in paperwork. And the defense firms that understand it will price their work before their clients force them to. Here is the bottom line. The billable hour was built for a world where legal work took the hours it took. Contingency overhead was carried because there was no other way to carry it. Both of those assumptions just stopped being true. The firms that win the next decade are not the ones with the most lawyers or the biggest office. They are the ones that rebuilt their economics around what their technology can actually do. The math has already changed. The only question is whether your firm rebuilds on its own terms or waits for its clients to do it for them. If this was useful, follow the channel, because this is what I cover. The collision between how law actually works and where our AI is taking it from someone doing both at the same time. Drop a comment with one workflow at your firm you think is ripe for this, because I read them and they shape what I cover next. Thanks for watching. I'll see you in the next one.